Good afternoon, and welcome to the Appellate Division First Department. I will begin with the call of the calendar. As always, please ask for the time that you need, not the time that you want. Understanding we have already 4 hours of argument time requested. And please know that even if I cut down your time, if the bench still has questions, I will not interfere, so the time will continue to run. So don't fret about the time that you get. People versus Joseph Jenkins.
Good afternoon, Your Honor. Appellate request 4.
Okay? 4 and 1 and 4. Vasquez versus Fordham University.
Afternoon, Your Honor. The appellant requests 5 and 1.
Okay? 5 and 1 and 5. S. Celia is a submit. Schwimmer, Kodos versus Tassler.
Good afternoon, Your Honor. The appellate requests 5 and 1.
Good afternoon, Your Honor. Respondent request 5.
5 and 1 and 5. Trujillo versus Shea is a submit. Zitman versus HSBC Bank.
Good afternoon, Your Honor. John Lee for appellant requests
7 and 3, okay. Okay, let's do 7 and 2 and 7, and fret not. If they have questions, you'll keep going, okay? All right. People versus Jonathan Moon. Submit. Ortiz versus City of New York. Okay. 3. All right. Manfredo versus 100-106 LLC is a submit. Now, the next case, Manning versus City Council of the City of New York City. This case is going to be called first, as 2 of the members of this bench will be recused and a judge has been vouched in, so we're going to do this one out of order, all right? Appellant?
I know a lot of people were planning on it coming a bit later, but so be it.
Okay, well, I'm trying to accommodate the needs of the court in light of the need for recusal, all right? So how much time would you like, sir?
7 and 3.
All right. All right, let's do 7 and 2 and 7. Floral Park versus Nationwide General.
Good afternoon, Your Honor. For the appellant, 8 and 2, please.
Okay.
Good afternoon for the respondent. Respondent request 4.
5 and 1 and 4. O'Sullivan is a submit. And Seibel versus Ramsey.
Good afternoon, Your Honor.
Good afternoon.
7 and 2, please.
Okay.
Good afternoon, Your Honor. Co-respondents 7, please.
All right. Let's do 6 and 2 and 6. And again, if argument takes us over, so be it. All right. We're calling out of turn Manning versus City Council of New York City. Both myself and Justice Moulton are recused on this case, and Justice Marsha Michaels has been vouched in. Come on in. Okay. Counsel?
Good morning. May it please the court, John Lobert for petitioner Roger Manning. I'd like to make 2 points. First, the zoning at issue should be annulled because it is irrational. And second, petitioner has standing to make this argument. First, a zoning amendment that invites uses and construction in blatant violation of covenants that the city concedes are binding on it is irrational, arbitrary, and capricious, and should be annulled. The city admits in the very first sentence of its brief that it, quote, assumed the obligation to preserve Governor's Island in accordance with the restrictive covenants in the deed. The deed prohibits industry, period. But the city proposed, championed, and enacted zoning that allows industry, including even industry.
So has there been any development that violates the restricted covenants in the deed?
No, I don't believe there has.
Okay, so there's nothing that has, at this point anyway, there's no city action that would, that goes against the vitiates or invalidates or goes against the restrictive covenants, right?
That is correct, Your Honor, and in fact...
So, I mean, where's the live controversy here?
Well, in fact, we are not suing, we do not allege a breach of the covenants.
Right, because you don't have standing to do that, right? You're not one of those parties.
What we
that
do
has
allege is that it was arbitrary and capricious and in violation of Article 78 for the city to enact zoning that allows, encourages, invites a breach of the covenants.
These covenants, are they in perpetuity or do they have an expiration?
Some of them are in perpetuity, and some of them have an expiration date. Your
The
Honor.
one that you mentioned, the manufacturing, is that one in perpetuity or does it have an expiration?
I believe it is in perpetuity, although I'm not 100% sure of that.
Is there currently a violation of the public trust doctrine right now? Is there currently a violation?
No, there is no violation of the public trust doctrine, and in any event, petitioner contends that the public trust doctrine would not be applicable here because no land has been dedicated as parkland.
So, I mean, I guess that's what we're trying to figure out. Why are you here now? Why not wait until something happens that actually you would allege violates a restrictive covenant, particularly because some of them are not in perpetuity. And we don't know whether 25, 30 years from now, someone's going to be able to use Governor's Island in a way that won't violate the restrictive covenant and would be consistent with the zoning changes.
Well, of course, that's possible, Your Honor, but we have a cause of action to challenge the
Yeah, I guess
zoning on its
that's right.
face.
But I mean, we're not in the habit of enjoining or telling the government to do something or not to do something that isn't currently in violation of the law, right?
Well,
I mean, there might be at some point, but it's not right now. We all agree it's not right now.
Yes, we agree on that, but it was arbitrary and capricious and in violation of Article 78 to enact this zoning.
Well, how do you know that they're not going to wait out the restrictive covenants and develop it at a certain period of time in the future? Why would that be arbitrary and capricious?
For example, one of the ways in which the zoning encourages violations of the covenant is that it allows residential uses of all kinds. Now, the covenant limiting residential uses does have an expiration, but it's 2060.
Okay.
So they could
And
have
is-
made this effective in 2060 if they wanted to, but they made it effective right now. So
Okay, but that's not illegal, right? That's not, there's nothing wrong with doing that. It's only if they then,
it's not illegal, but it's irrational and arbitrary and capricious.
so let me ask you this. Are there not many places where there are inconsistent restrictive covenants in particular deeds and zoning resolutions that are inconsistent with those restrictive covenants? And we don't strike them down, right? We do
well-
nothing. In fact, they're separate.
Well, that's the city's argument, but
Are that, haven't we held that?
sorry?
Haven't we held that in more than one case?
Yes.
That they are
You
separate.
have, but in none of those cases was the city the covenantor. In every case, it was the covenantee.
Okay, but
or
why
it
does
was
that
completely
make a difference?
extraneous to the covenant,
Why does that make a difference?
because this is analogous to the city violating its own rules or breaching a contract that it has entered into. And for that reason, it is irrational and it is arbitrary and capricious.
Well, counsel, it would be a breach if something actually happened, if something was actually built in violation of the covenant, but you've conceded that nothing has actually happened.
I'm sorry,
I said it would be an issue or a violation if something was actually done, if you had a claim that was actually right, but nothing has been built.
Right, but we do not have a cause of action under the covenant. So this is the only chance for members of the public to object to this zoning. And we believe we have a right to challenge it on its face as arbitrary and capricious. And there is case law that says that zoning that violates a contract, we cited the Wawayanda case, that violates a contract is arbitrary and capricious. Similarly, there's case law saying that the city cannot violate its own rules. Very comparable.
So let me ask you this: couldn't you, if there was some kind of, you're saying you can't challenge it, this is the only way to challenge it, but couldn't you challenge it under the public trust doctrine at the time of the?
No, we could not, because contrary to what the city has represented in its brief, it has not dedicated any land as public parkland. Public parkland to be designated requires a definitive, explicit act of the municipality.
Right. So isn't that the whole point? Go to the city council, do what is required to make sure that the parkland is designated. And then if there's something, the problem is there's nothing going on here right now, right, that would violate.
Right, but we allege that this zoning is unlawful on its face because it's arbitrary and capricious, and arguably even unconstitutional because it's so irrational and violative of due process.
Okay. All right. Thanks. You have some time on reply, right?
Okay.
Counsel?
Thank you, Justice Scarpula. Jesse Townsend for the respondents. We ask that this panel affirm.
Yeah, so what is the point of the resolution, the zoning resolution at this point where the restrictive covenants clearly prohibit you from developing?
Because, Your Honor, the restrictive covenants do not prohibit us from all development.
Fair enough, not all development.
So, for example, you can see this on page 93 of the record. One requirement is that we develop educational facilities. One type of educational facilities can be a research facility. So when Mr. Lobier refers to, I think it's 1659 of the record, where in the zoning resolution, it was amended to allow certain types of industrial activity, including research facilities, or research, I think research laboratories is the language. In order to effectuate the restrictive covenant, which requires us to build an educational facility, we have to have some amendment to the zoning resolution to allow
This is
that.
pretty broad. It's not just that. It's a pretty broad amendment to the zoning resolution, right? So assuming that that is true, why not just do a much narrower zoning resolution that would permit you to build what you're required to build under the restrictive covenants, but not permit you to build what you're not permitted to under the restrictive covenants?
Two answers, Justice Scarpula. The first is, I use the educational facility as one example, but on page 94, you see there's a whole list of other permitted uses. That may include retail, restaurants, and then along with that, if for example, if a tap room can be opened, which it can be. That's the type of restaurant, essentially. It may have a microbrewery attached to it, and we need to have an amendment to the zoning to allow that sort of small-scale artisanal activity as part of one of the options available for development. The other answer, though, Your Honor, is that we are talking about zoning legislation. And zoning legislation usually doesn't pick up the exact language of a deed restriction. It's just not practical for the city to do so when amending its resolutions.
Fair enough, but you agree that at some point, if the city tried to develop in a way that was contrary to the deed restrictions, that there would be a path to challenge that action?
There would be a path for the benefited party, which is the National Park Service. That's the party that can enforce the deed restrictions. And there's a whole process for raising that with counterparties,
Right.
Agreeing to a change in use, or potentially litigating. And then perhaps it would be the National Park Service here instead.
Or as I suggested, the petitioners can go to the city council and say, you need to do this. If this is what we, the citizenry, want to have happen with this piece of property, designate it, and then that would raise more other issues. But the status right now is not that.
That's absolutely right, Justice Scarpula, and I would just add that, of course, this process did go through the ULURP process to begin with. There was extensive feedback and input from the community boards, the borough
Who
president.
in fact originally nixed it or rejected it.
That's right. It is an advisory process, but it allows for public input, and ultimately went to the city council, and the city council decided, as amended. Each of those steps did allow some changes and modifications to try to take into account public concerns. But it reached a democratic resolution with the city council passing the zoning resolution. And just to pick up on one thing that Justice Mendez mentioned, these deed restrictions do, for the most part, expire. The industrial use, for example, expires, I believe, by 2060. You see that on page 95 of the record. The only one that's perpetual is the parkland. And so, although I'm not saying this is by any means respondent's plan, yes, after 2060, even if there were a hypothetical conflict between the covenants and the zoning as of now, that would go away, and we would just have the zoning resolution as it is written. The last thing I would just say, Your Honors, is that the parkland does exist. It has been built. The respondents have spent millions of dollars to create a 43-acre park. It exists. And nothing has been done, nothing has even been proposed that would take that parkland out of park use and put it to some other use. And for all these reasons and for those...
But does the resolution put that in jeopardy? Because that's really what we're here about, right? Individuals who don't want the parkland to be taken away.
The resolution does not put that in jeopardy, Your Honor, because the part that is park is covered what we call the open space sub-area that covers the parkland and the esplanade, which is the other sort of public space. And in those areas, there is a much narrower set of uses of it.
What is the area right when you get off the ferry? What part is that where there's that bar and then the bike paths and all that?
So the area right when you get off the ferry was probably North Island, which is the historic buildings. And that's already covered by an earlier zoning, so which already, again, protects the historic buildings in that area. All of this, which is at issue now, is South Island, where there are basically two things. There is this 43-acre park that the city has, or the respondents rather, have built and opened, and there are literally fenced-off, falling down, non-historic buildings. And the development...
Those are not the buildings that you can go into where the artists are and...
Right.
Okay.
They're fenced off. They're not publicly available. They're not historic. They're not protected by historic preservations. They're falling down buildings.
And they're not where the Coast Guard people used to... Are those the buildings you're talking about? The brick buildings?
No, those are all protected by historic, and I think those are all on the north side of the island.
Right.
And part of that's actually a national park monument, so that's even outside of our jurisdiction entirely. But this is all about developing areas that are literally fenced off from the public, that are not historic, and that will be used to develop uses that are required or permitted under the deed. That is what the resolution is meant to do. Unless Your Honors have any further questions, we ask that you affirm.
So, well, the city apparently concedes that only the National Park Service can enforce this restrictive covenants, and it's not really, when the federal government turned this land over to the city and the state, it did the best it could, because under the law of restrictive covenants, the only enforcer has to be someone who traces their title from a common grantor. So I couldn't have given rights to enforce to the public, but nevertheless, this had some meaning, and many citizens, including the borough president and many, many others.
Yeah, but that process already happened, right? The
Yes.
borough president and the
Yes.
community board made their input.
Yes.
Changes were made. I mean, it's not that those citizens didn't have an ability. They did. Changes were made to the plan, correct?
Very minor changes.
Well,
were
okay,
made.
they're right, but I mean, that is the way we work, right? We
Right.
can't have individual citizens just deciding
But-
for the
but-
citizenry.
But if I may, I'd just like to point out how disingenuous the city's brief is on all these points, because, you know, the city claims that the zoning limits industry and manufacturing when it doesn't. It doesn't say anything about the scale of it. It even allows industry and manufacturing in use group 18, which is the most, which according to the zoning resolution involves considerable danger of fire, explosion, or other hazards to public health and safety, and normally generates a great deal of traffic. In addition, the city claims that it has dedicated 43 acres. It has not. It claims that the zoning limits the use of the open space areas.
Well, I
when it
mean, the
does
problem,
not.
of course, with an Article 78 proceeding is that we don't have the ability to assume that your version of the facts are correct and the cities are not, right?
Well, no, Your Honor, it's plain on the face of the zoning resolution what it says. I mean, it says that manufacturing is prohibited until 2060. It says that the
Well, I think that's right. I don't
and they
think the city
deny it.
just-
So-
No, the city just admitted that
no, but what they deny is they say they've dedicated parkland. They have not dedicated parkland. And if somebody were to sue under the public trust doctrine in a few years, they'd say, well, you know, there's no dedicated parkland here, so you can't use that cause of action. So they say the Governor's Island Trust would block construction and uses that are violative of the deed, but they don't even concede that the things that are plainly on their face violative of the deed are indeed.
Well, a zoning resolution is completely different from something from construction, right? We agree
Right,
with that.
right.
Okay. All right, thank you very much, Council.
Thank
Thank
you.
you.
All right. Vasquez versus Fordham University. Justice Mendez is recused from this case. Oh, I'm sorry. Took him out of turn. Who'll be next? People versus Joseph Jenkins. Thank you, Judge Mendez. You step out of the room and you get all disoriented. You see that? You may proceed. My apologies.
No problem. So, good afternoon, Your Honors.
Good afternoon.
And may it please the court, Rebecca Martin for Appellate Joseph Jenkins. Your Honors, the prosecution here did not establish either Factor 1, forcible compulsion, or Factor 12, failure to accept responsibility by clear and convincing evidence, and therefore Mr. Jenkins should not have been assessed points under those factors. And in fact, not being assessed under either of those factors, let alone both, would be enough to take him from a level 3 to a level 2. In the alternative, if you don't agree with me on either points, then he should have been given a downward departure from a level 3 to a level 2.
On this case, we should give this man a downward departure?
Yes, Your Honor, and particularly for the reason I wanted
Counsel, look, I understand, having been in your shoes many, many years ago, I understand the absolute incredible work that advocacy of criminal defense attorneys. But on this case, he digitally penetrated a 4-year-old
Yeah,
and would have penetrated with everything else had the child's father not walked in.
yes,
So, I'm sorry, how this case would at all qualify for a downward departure is beyond me.
Your Honor, I think the main reason, which also goes to my points arguments, which so perhaps I'm hearing that that might be the best place to focus, is this question of acceptance of responsibility. Because I think the record is.
So did he ever deny responsibility?
Your Honor, at Doc's intake, he did.
did. He denied it, right?
He did that one time. However, he had also accepted it many times before, and then also addressed the fact his substance abuse, which was one of the
He
contributing.
did not participate in the sex abuse program while in prison. So how is that not evidence of a failure to accept responsibility for your behavior?
Your Honor, I think that goes to kind of the more technical legal question that we were raising here, which is what is required for that 15 points under failure to accept responsibility? Because what the guidelines lay out is, you get a certain amount of points for failure to accept responsibility, and then you get an extra 5 if you if you refuse the sex offender treatment. Because what the guidelines say is, and this is on page 16, they add 5 points if the offender has refused or been expelled from treatment. Because such conduct is powerful evidence of continued denial. So it seems that the guidelines are contemplating that that's kind of.
So wait, but in this case, he denies that he denies responsibility at his intake, right? And then he refuses sex. It is a continuing refusal to accept responsibility. It is not a one-time, because I felt bad type of thing. He continued to refuse to accept responsibility while he was incarcerated and before he was incarcerated, right?
And the only time he accepted responsibility was in order to obtain a favorable plea.
Your Honor, that is what respondent argues.
That's what the facts bear out. Where after he gets into prison does he acknowledge that he attempted to rape his niece?
Your Honor, it's true that the facts do not say that he said it out loud. He did attend the alcohol and substance treatment, which connects.
But not the sex abuse, not the sex abuse treatment, right? That's a completely different thing. He did not, you're saying he showed that he accepted responsibility for trying to rape his 4-year-old niece by going to substance abuse therapy?
Well, that was a contributing factor to the incident, so I do think that it was trying to address one of the underlying causes.
You'll have time on rebuttal. Counsel? You may proceed.
Thank you, Your Honors. May it please the Court. Charles Hickerson for the people. Your Honors, this court should affirm defendant's level 3 sexually violent offender designation.
What do you say about the defendant's argument that you have not proved by clear and convincing evidence that there was forcible compulsion?
Your Honor, obviously the people disagree. As borne out by the felony complaint and the board's case summary and defendant's own statement to authorities, the defendant held his niece's head. Well, first he bent her over a chair, held her head down, and with his penis exposed in one hand, with the other hand, digitally penetrated his niece. I would say that.
And that was corroborated by her father, right?
Yes, Your Honor.
The father.
Yes, Your Honor. The father's named.
Right.
He testified in the, or he's in the affidavit for the complaint. And defendant corroborated with his own statement to authorities, which was also in the felony complaint.
Did the court consider the mitigating factors?
Most of the ones listed, Your Honor, were before both the board and the SORA court. For instance, defendant's age at the time of the offense, 45, and he did 6 years, so he's not, frankly, he's not that elderly.
He's not old at all.
You all know, Your Honors. And
speaking for everyone on this bench, he's not old at all.
Of course not, Your Honor. And in terms of the other mitigating factors that were brought up, they bring up acceptance of responsibility, but we covered that pretty thoroughly earlier. The alcohol assessment, we just talked about that that's not response to treatment, if exceptional under the guidelines, can be a basis for downward departure. There's no evidence that it was exceptional, and also his refusal for the sex offender treatment sort of negates the drug and alcohol treatment. And also, his criminal history was accounted for by the board. He was assessed no points under that category. And the other claim, oh yeah, and the only other was the age that I brought up earlier. And unless your honors have any further questions, I'll rest on the brief.
Thank you.
Thank you.
So to address the forcible compulsion point, I believe that there are two facts. One is the father's statement that Mr. Jenkins was holding down the complainant. However, I think a third party's kind of impression. I do think holding down would amount to forcible compulsion, but holding down, because it implies a force, but a third party's impression in this fleeting moment that then quickly turned in, and understandably turned into an altercation, that is not clear and convincing evidence there actually was force. He wasn't experiencing what was
You
happening.
think a father who saw his daughter and what was going on, that wasn't enough and he said? I mean, clearly it doesn't matter that it's hearsay. So
No, the question is,
the father saying, this is what I saw is sufficient?
I think it's hard to, particularly given the fleeting nature of what he saw before.
Look, even if I didn't have the father's observation, I have a 45-year-old man versus a 4-year-old child.
Yes, Your Honor, and
I can almost say, without hearing anything else, there is control over that child.
Your Honor, forcible compulsion does require kind of an application of force. Obviously, the
And
disparity.
we have that here.
Your Honor, my argument is that the statement, what we have is that he bent her over. That's not necessarily an application of force. That is something that could be.
He was holding her head down
The-
as she was bent over a chair so that he could penetrate her from behind. That's what was going on.
Your Honor, I will just say that the statement of holding the head down came from the father's observation. I think we do not know whether or not there was force being applied.
Did he deny it? I thought your client admitted that he did that.
He
and
admitted
had
that he
the
bent
father
her
not
over.
come in, he would have forcibly penetrated that child, is what he admitted to, right?
He admitted that he would
Have
have
penetrated her.
but that had not yet happened. The question is whether forcible.
No, well, not with his penis, but it had already happened with his fingers.
And he said, I bent her over.
Yes, Your Honor, and as I argued in brief, I don't believe that bent is necessarily involves that application.
I bent a 4-year-old child over, you don't think is clear and convincing evidence?
No, Your Honor, bent. I think it's clear that we're not going to see eye to eye. But, so I rest on my briefs. Thank you.
Thank you so much. Vasquez versus Fordham University. Justice Mendez is recused on this case. Should we have a tie, a fifth judge will be vouched in. You may proceed.
Thank you. May it please the court, my name is Michael Mangan. The respondent in this case, summary judgment, failed to eliminate all issues of fact as to whether the respondents had actual or constructive notice of a defective light over a staircase at Finley Hall. In addition to that, there's a couple of other issues about whether or not the respondent was able to establish a prima facie entitlement to summary judgment as far as the staircase, but this is an illumination case, or I should say a lack of illumination case. The facts here that are important and what it was that are not refuted are that for 10 days, from July 2nd until July 11th, at the time of the fall, there was flickering lights.
Flickering, but not off. That's the issue. The first time that your client noticed that the lights were off was the day of the accident, correct?
Well, she noticed that they
Is
were.
that correct?
The first time that she noticed that they were completely out
Right.
was on the day of the accident. That's correct. And what she said was she didn't go out of the hall at night very often. But yes, it's very important that these flickering lights. The question is whether or not the flickering lights are a defective condition that required addressing. That's what this comes down to. And what I would submit to the court is that the flickering lights themselves, first of all, Fordham's own chief maintenance officer, Mr. Standler, testified. When there are flickering lights, they have to be reported. They have to be reported into the e-work system for correction, either whether it's a ballast or whether it's a light bulb. It has to be corrected. I would also say to you that the flickering itself, not only is it a potential dangerous condition if you're walking down a staircase.
But that's not what caused her fall. Her fall, you're alleging, was caused by a light that was off. So there's no causal connection between an alleged flickering, right? You're saying the light was off, right?
That's right.
So when you look at that, when was the first time that anyone had noticed that the light was off?
Well, the first time that we have in the record on this, and I should also mention this, Your Honor, we had not completed discovery because the moment the depositions were taken, the first time that the plaintiff had an opportunity to depose anybody from Fordham was in March of 2020. That was the very first, and within a week, everything was shut down. Before we had resumed, before there was another conference, there was a motion for summary judgment that was made.
Did you argue to the court below that there was evidence that you needed that you didn't have?
I did. I absolutely
And what
did.
happened?
It was rejected.
Okay.
It was
But
rejected.
I didn't see that you didn't appeal that part of it, right?
I did not appeal that part.
So we can't, let's just talk about
Well,
what's in front of us. 'Cause
I-
even though, I mean, just
That's
for
right.
the first time we hear that the light is out is the night, right?
The first time that we know that the light is completely out is of that night. Yeah, that's correct.
Okay.
However,
That's where we have to go, because that's what you're alleging caused her to fall.
but what I'm saying is that
Is that the only cause, though? Is the lighting the only cause for her fall? As I understood the record, there was also testimony by your client concerning the unevenness of the steps.
there's a contributing factor of the unevenness of the steps. That's correct. And by the way, the steps were completely removed. We were never given notice that they were being removed.
But I saw nowhere in the papers that the plaintiffs sought an inspection in discovery orders, nothing like that. No request to retain the steps in their condition, nothing.
Your Honor, that's true. We didn't request to retain a set of steps, blue flagstone steps that had been in place since 1906. In part, I would say, and the reason for that was, first of all, it was at issue. They knew it was at issue.
Yes, but the steps, it's not like the steps get carried away. They are a permanent structure. It was 3 years since the happening of the accident, before those steps were replaced, which afforded plaintiffs more than enough time, even under COVID. Don't use the COVID excuse on this one, because these are outdoor steps. You could have walked up to the campus and photographed those steps at any time.
We were not permitted inside the campus. I had to make a request. Once I learned that they had removed the steps, and they made a motion for summary judgment.
No. Let's start with, when did you file the complaint?
I filed the complaint in 2017, December.
2017. So 3 years before the start of COVID, she alleged that was a contributing cause of the fall. Did you ever, during that 3-year period, inspect the steps?
No, but just as long as we're going to talk, if I may, just about the timeline, if I can.
I'm going to give you 30 seconds, because you see your red light is on, otherwise
I
you can
do.
use your rebuttal time.
I do. The defendant was in default, and we permitted defendant to submit an answer, and they didn't answer until March of 2018. They didn't provide any discovery until 2019, and we didn't receive any reports of anything to do with
That has nothing to do with whether your investigator goes to look at the steps. Whether they gave you any discovery has nothing to do with you sending over somebody to take a picture of the step in 2018, 2019, beginning of 2020.
You'll have time to
Thank you, Your Honor.
respond to that on rebuttal.
I appreciate that.
You may proceed.
May it please the court, on behalf of Fordham University. Regarding the texture issue, actually plaintiff testified that she did not slip on anything. She did not trip on anything. She only testified that something wonky happened and that there was something with the texture, but she didn't explain what about the texture. And the lower court.
She said it was uneven.
Right. And our expert.
Yeah, should we consider, I mean, say we do consider your expert's report, you know, we don't agree with this spoliation argument, but he examined the steps 3 years after the accident. Shouldn't we greatly discount his report because of that?
It was the same steps, and you have photos from the month of the accident and photos from 2021. It's the same step.
Yes, but we know that we live in New York State where it snows and it rains and it gets frozen weather and it contracts and it expands, so that the way the texture was on the date of the accident is not necessarily what your experts saw 3 years later.
Right.
And we have case law that says that an expert's opinion taken about, regarding observations of a location taken 2 years beyond the accident is of no probative value. So why should we consider your expert's observations 3 years later probative?
Because in that case, in the situations that you just cited, the staircase would have gotten worse, not better.
How do I know that here? Again, this is an old 1906 stone staircase.
And you know, you look
What-
at the
what-
photographs, there's like cracks. I mean, it's not clear from the photographs that there was no possibility that she could have. I'm looking at, I mean, these are not great photographs, but I did look at them, and there are spots where it's cracked and miserable. Uneven.
Well, on the second step, which is what we're talking about, the expert measured the second step and found it to be level. There may have been other steps that weren't level. That's
Yeah, but again, that's 3 years later. That's the problem. Did anyone say, did you put in an affidavit from anyone at the Fordham that said on the day of the accident or on or about the accident or a week before or 2 weeks after, I examined the steps and there was no cracks, no nothing? I mean, I'm looking at these pictures. It doesn't look, I can't tell.
And that's true. But again, she doesn't say that that's what caused her accident. She said something wonky happened, and the lower court.
Look, if you want this court to get stuck on the fact that a 19-year-old used the word wonky,
And
I can suggest to you that that is not your strongest argument.
She didn't clarify what caused her accident.
Okay. Does our case law require a plaintiff to be able to exactly say what caused the accident, as opposed to, this is what I experienced, my ankle kind of rolled out, and afterwards I looked and I saw that it was uneven? Don't we have thousands of cases that kind of fit that fact pattern?
Your Honor, she has to say something. She didn't articulate any reason. And also, she had an affidavit in opposition, which she could have articulated as to how the accident occurred on some
Well, she
level.
said it was dark because the lights went out, she couldn't see, and there was an uneven surface. Why are those two things not enough?
Because the darkness didn't even cause the accident, because she acknowledged that the first step, she was just fine. The second step,
But counsel, she did say, I couldn't see well and the steps are a little irregular. I mean, right? She said that. I couldn't see well and the steps are a little irregular. That's what she said what do you mean by wonky, right? So if I mean, maybe that doesn't say much, but it doesn't say nothing, right?
it doesn't articulate as to what that even means. I mean, on any level.
It's a 19-year-old college
Again,
student.
she had a second crack at the apple and affidavit in opposition. She could have taken her time and articulated something. She did not.
Okay, thank you.
Your Honors, on that point, just addressing what was just being discussed a moment ago, she did give testimony, and she actually identified in a photograph location where she, her left
That
foot
was
had landed.
Exhibit C, right?
I believe so, yes.
Exhibit C, I don't know, those steps are pretty flat and uniform. You know, if one's very charitable, you can see sort of some irregularities in the bluestone. But let me ask you a slightly different question. Can't we rely on the photographs she took soon after the accident and compare them with the experts' photographs, which were taken 3 years later, and say, yeah, okay, the steps basically look the same, so the expert was looking at the same set of steps, essentially? Can we do that?
Well, I don't know. I've spent a lot of time looking at those photographs, and I've tried to use what I possibly could to compare them to see if they are identical. Unfortunately, the photographs that she took and the quality of the pictures are not fantastic. That's for one thing. Secondly, it's difficult to say exactly. We never got an invitation to go with the inspection. I know the CPLR doesn't necessarily require it.
They don't have to invite you.
I know.
Especially where you didn't reserve or request to be invited to inspect.
And you're suing them.
Okay, I would like to make may I make one final point? I see that my time is up. On the question of flickering light, what I would analogize that to is a broken glass or a frayed rope that is about to break. And we know in our common understanding that a flickering light means a light is about to go out. And so as far as the testimony of Stadler was, who's their person, that has to be reported and it has to be repaired. And the reason for that is it's a safety issue.
Thank you.
Thank you.
Schwimmer, Kodos versus Tassler. You may proceed.
Good afternoon, Your Honors. May it please the court. My name is Ryan Dukman of the law firm UL Legali Benetra for the defendant appellants. Summary judgment should have been granted in this case for 3 reasons. First, plaintiff's expert affirmations were insufficient as a matter of law because the plaintiff's experts never read our expert affirmations and did not substantively engage with them. Moreover, their experts repeatedly misstate key facts to justify illegitimate criticisms of Dr. Tassler's care. Second, Dr. LaSala, the neurosurgeon, did not need to be in the room when the closure was done, and he was not in the room when the injury occurred, so all claims should have been dismissed against him. Finally, with respect to Dr. LaSala, the ENT, the injury that occurred was a known risk of the procedure, and all of plaintiff's alleged criticisms are not based on what Dr. Tassler actually knew or what he actually did, and therefore they do not raise an issue of fact. Beginning with point number 1. This court's case law is clear. In order to find an expert affirmation to be sufficient in opposition to a motion for summary judgment, the expert must substantively engage with the other expert's opinions.
Didn't they engage with Dr. Tassler concerning the use of the instrument that he used to remove the mucosal part of the surgery?
Your Honor, there are comments by their expert about the general idea of how mucosal removal can be done, but their expert does not ever actually substantively engage with one.
That's not accurate. He says that instead of using the forceps and pulling it off of out of the location, that it should have been dissected in order to make sure that there was no injury to the artery that had I don't know how to pronounce the medical term, but it had dropped basically. And so, and there was a thinning of the bone inside the nose. And so the expert, while there are some issues with regard to the expert's opinions concerning Dr. LaSala, for sure, with regard to Dr. Tassler, the expert's affirmation was very pointed, very specific about the ways in which that expert thought that Dr. Tassler had deviated from good practice.
Your Honor raised a few issues that I'd like to take in turn, because when you dive into what their expert actually said, when you look at what they said, it doesn't actually establish a question of fact, because what their comments are do not apply to the case. For example, the first thing Your Honor brought up was this issue of that he could have scraped the mucosa off the artery. That is something their expert says was an alternative that could be done, except that the evidence shows that the mucosa was attached to the sphenoid sinus bone. That's what the record shows. It wasn't attached to the artery. You can't scrape something off an artery when it's attached to the bone.
He didn't say scrape. He used the word dissect.
He says dissect off the surface of the carotid artery. It wasn't attached to the carotid artery. The mucosa was attached to the bone. That's a perfect example of
Which
how
was
their expert...
immediately adjacent to the artery, no?
It's in a different place. The mucosa that was removed, the circumstance which Dr. Tassler was confronted with, was a piece of mucosa attached to the sphenoid sinus bone. That was the circumstance.
Well, but it wasn't the bone that bled out, right?
Yes.
The pulling of the mucosa caused extreme bleeding. So that bleeding didn't come from the bone, it came from the artery, correct?
Yes, Your Honor.
Okay.
But that doesn't mean that what Dr. Tassler did was a departure from good and accepted medical practice.
Why is this not a battle of the experts on this, speaking specifically about Tassler and this particular issue?
Your Honor, it's because this was a known risk of the procedure. That's undisputed. And what you're describing, that expert's criticism, is not the situation that Dr. Tassler was confronted with. That may very well have been a legitimate criticism if Dr. Tassler was removing a mucosa from the surface of the artery. He wasn't. He was removing the mucosa from the bone. Plaintiff is almost certainly going to get up here and say, well, my expert also says it was a departure to remove the mucosa when the bone is thin, which Your Honor also brought up. His expert does say that. However, only 2 pages later, on page 7,684 of the record, that same expert concedes that you can safely remove a bleeding mucosa in the context of a thin sphenoid sinus bone. And by making that concession, it became incumbent upon plaintiff's expert.
But the question is not whether it can be removed. The question is, can it be removed in the manner in which your doctor did it? So does the expert say that specifically?
That's precisely our argument, Your Honor. Their expert never addresses the actual way that Dr. Tassler removed the mucosa or appreciates what he understood, because all of their criticisms are based on him not knowing where the carotid artery was and not knowing about the thinning in the sphenoid sinus bone, which is directly contradicted by the evidence.
I don't know that that he went so far as to say he didn't know where the carotid, where the artery is. Does he specifically say that?
Yes, Your Honor. On multiple occasions, he says that due to Dr. Tassler's failure to order an ultrasound, he was unaware of the location of the carotid arteries, which led to the injury in this case. That is what his expert says over and over again. And that is one of the many reasons why his expert affirmation.
Well, let me just ask you, why is that not a sort of a disputed fact issue? He does say that the Stryker software was not sufficient in this particular case and that it should have been a sonogram. So your doctors say, no, Stryker software was perfect, and plaintiff's doctors say, nope, should have been a sonogram.
Your Honor, there is no question of fact on that issue because plaintiff's counsel in his papers certainly said that his expert said that an ultrasound is better than neuronavigation. But if you look at the actual citation to the actual expert opinion, it says no such thing. In fact, other than in the fact summary of their opinion, the words neuronavigation are nowhere to be found in the expert opinions by plaintiffs, which is a crucial point in this case.
But I thought he explained that the reason why the Stryker system was not ideal is that the Stryker system basically photographs the anatomical structures prior to the beginning of surgery, and once surgery begins, its placement, the placement of those structures may have moved based on the surgical procedure. And here we know that the tumor was so large that the doctor, one, was surprised at how large it was and had to conduct his surgery in a way in order to be able to pull out that entire tumor through the nasal passage before letting Dr. Tassler come in for the closure. But I'll let you, so I mean, as I'm listening to your arguments, I'm thinking about what I've read and why I'm not so sure that your last statement is kosher. But I'm going to let you talk about that on rebuttal, okay?
Thank you, Your Honor.
All right.
May it please the court, my name is Jeremy Barberi. I'm an attorney with the law office of Bruce Lane, and we represent the plaintiff's respondents in this matter. I guess I'll start at the end.
Can you say what did your experts say were Dr. Tassler's departures?
Sure. Number one, the departures all increase the risk of injury to the left internal carotid artery. Number one, they missed it on the preoperative CT scan. Number two, they plugged that data into the neuronavigation system, that data which is now 3.5
Why do you draw the first conclusion that, I don't mean to get in the midst of your list, because I know you have a lot of things to list, but they did discuss the carotid artery, they said, prior to surgery. Both Dr. Tassler and Dr. LaSala, they said they did that.
They said they did what? I'm sorry.
They did examine the left carotid artery.
When?
I said pre-surgery. They both said that. They both testified that. So why are you drawing an opposite conclusion? Like, why do you say they did not do that?
Well, they may have examined it, but the fact of the matter is the preoperative CT, which our ENT expert put the little arrow there and showed what was going on, the bone was thinned down to paper, and the artery was dehiscent into the sphenoid sinus. So number one, they missed that preoperatively, increasing the risk. If they knew that the artery was dehiscent into the sinus.
There was no question that your client needed this surgery. He had to have this tumor removed.
That is correct.
Enormous, right?
That is correct.
So he was going to have to face certain risks of procedure.
Correct.
So, and one of those risks is that there can be injury to the artery. So
Yes.
why did that eventuality here become a departure?
Well, that's the point I was getting to earlier, is that all along the way, there were things that were done and that were not done that unnecessarily increased that risk. Missing it preoperatively, taking the preoperative data, loading it into the Stryker system, the data which is now 3.5 months old, failing to do the intraoperative Dopplerography, which would have been real time, increasing the risk, deciding to do a nasoseptal flap closure instead of a simple closure, increasing the risk. If you insist upon doing the nasoseptal flap closure, you carefully dissect the bleeding mucosa, move it to the stable clivus, which is my understanding, it's a bone right off to the side that you can easily then remove without having to pinch. All of these things unnecessarily increase the risk.
Okay, now, so assuming I accept all of those things, right? What does that have to do with Dr. LaSala?
Because Dr. LaSala is the neurosurgery expert.
But his expertise was not in the removal of this particular tumor, right?
No.
That was the ENT.
No, the removal of the tumor was certainly, you mean the mucosa?
Yeah.
Okay, the mucosa, generally speaking, is the province of the ENT.
Right.
But the problem here is that you have a piece of vasculature which is normally protected by this bone that's now sticking out into the area where the ENT is operating. At that point,
So essentially what you're saying is he should have said to the other surgeon, don't injure that artery?
he should have said to the other surgeon, and this is part of the problem with the SALA as well, he didn't know that it was dehisced. Why didn't he know?
No. What are you saying he should have done that he didn't do?
What he should have done, first of all, is ordered the intraoperative Dopplerography, because then they would have seen
We're
it.
talking about Tassler's departure now. We were focusing on LaSala. and why he
I'm
had
trying
to
to
be
focus
present.
on LaSala.
Yes,
Yeah.
as am I. So
Because we agree that the injury, the injury that brings us all here happened during the closure,
correct,
not during the operative procedure that Dr. LaSala was part of.
correct,
His part of the surgery was done.
correct,
And now Tassler was supposed to come in and close out.
correct,
And it was during that process, when the doctor is not even, LaSala is not even in the room, that the bleed begins, correct?
correct.
Okay, so the premise of your expert is that he should have stayed in the room to what? Lean over his shoulder and say, no, be careful. It seems ridiculous, actually.
With all due respect, I disagree. And as I was saying before, when that artery was now dehisced or present in the left sphenoid sinus, now you have La Sala, the neurosurgeon's area of operation, intermixed with the ENT's area
How
of
is it
operation.
intermixed? How could it be intermixed? What could he do? He could just say, hey, listen, don't hurt that artery?
Well,
He's not going to like push him aside.
well, yes. If he had done if they had ordered the
Counsel.
intraoperative Dopplerography, they would have seen it. And at that point, La Sala would.
But even if they had done at the end of the day, it would still have been Dr. Tassler closing.
Correct. But La Sala was still a proximate cause of that injury.
How?
Because the fact that they didn't order the Dopplerography, they didn't see it.
What did he do during his procedure that somehow caused that injury?
During the actual takedown of the tumor,
Yes, mhm.
I would concede that, and we said this in our brief. He did nothing during his takedown of the tumor to injure the artery. I absolutely agree.
Was Dr. Tassler an experienced ENT that had done this type of surgery many, many, many times before?
I don't know about many, many times, but he did testify that he did have experience with this procedure. That's correct.
So then you are expecting Dr. La Sala to somehow stand over and supervise an experienced ENT in his field of specialty.
Yes, when part of the neuroanatomy is now in the area of expertise for the ENT, yes, I do expect that, because again, those two areas, there was usually supposed to be a clear wall between them. In this case, that didn't exist. They missed it preoperatively, they missed it intraoperatively. If he was there and they had done the proper studies, none of this would have ever happened.
All right, thank you.
Thank you.
Your Honor, the only experts in this case who ever commented on what the neuronavigation in this showed was defendant's experts.
No,
The
yeah,
word
let's
neuron-
go back to Tassler. Let's leave LaSalle. But here's what plaintiff's expert says. It says that since your client decided to do he was going to use a nasoseptal flap to close, he should have used Doppler sonography, and then not use the Blakesley forceps. That's what he says, right? And that's what I was asking you about before. That's what he says the departure is, that he should not have used the Stryker technology. He should have used a sonogram, and he didn't.
Your Honor,
may
if I may
answer.
respond?
Yes.
Once again, in the actual analysis section of plaintiff's expert opinions, the word Stryker is never seen. The word neuronavigation is never seen. That is plaintiff's counsel's misrepresentation of what their expert said. He never says that. What their expert does make the limited claim that an ultrasound should have been done, but he doesn't say it was preferable to the neuronavigation system, and he completely ignores the crucial fact that the neuronavigation system, sorry.
I'm looking at his affidavit. I think you're parsing it out to such.
Yeah.
He definitely does say that he should have used the Doppler.
And
Whatever he did, it wasn't what he should have.
That sonogram would have been in real time as opposed to a study that was conducted preoperatively and loaded up. And in light of the operative findings that this tumor was massive, okay? Between the time of the image that was uploaded into the Stryker system and the actual surgery, do I know how much bigger that tumor grew and what it may have done anatomically inside of inside of the plaintiff's body?
Your Honor, if I may briefly respond. The comment that this is old data and it wasn't showing real time, never made in their papers, never put in the expert affirmation. That's a new argument that cannot be considered.
Counsel, if I pull the documents from your papers and I look at the information that was put into the Stryker system, would it not have the date of the information that was uploaded into the program?
The location of your carotid artery.
Answer my question.
Yes, Your Honor.
Okay. So then everything else is, I have the date, and it did predate way before that surgery, that diagnostic that went up into that system. So that argument is not nothing.
No, Your Honor, but it also doesn't matter because the location of the carotid artery doesn't change. The location of your brain doesn't change with 3 months. And more importantly, it's not just the neuronavigation system that is proof
You're
that Dr.
saying that a
Tassler-
vein can't be moved around if a tumor is growing and shoving things aside?
The
Is that
general
what you're
location
saying?
of the carotid artery, no. And in this case, we know proof positive that Dr. Tassler knew where the carotid artery was because he wrote in his operative report that he dissected laterally up to the left and right internal carotid arteries. That is further documentation that their experts repeatedly ignore. He knew where the carotid arteries were.
Okay.
It's totally made up.
Thank you.
Thank you, Your Honor.
Trujillo, no. Zitman versus HSBC. You may proceed, sir.
Thank you, Your Honor. I'm John Lundeen, counsel for plaintiffs in this action, plaintiffs appellant. This appeal arises from the motion court's decision to grant HSBC's motion to dismiss. That decision was based on several incorrect holdings of misunderstandings of the law and findings of fact that simply were not facts and were not alleged. Indeed, some were based on arguments that were not made at all. A key issue in this case is class action tolling, recognized in this state by the Court of Appeals decision in Chavez. And one of the things that the motion court said was that plaintiffs' claims were not told by the BlackRock class action because
Because they didn't involve the same, well, for a number of reasons, but one of them was that they didn't involve the same claims. Your client is raising a defective documents claim, and the people in BlackRock maybe talked about that glancingly, but mostly the gravamen of that case was different.
Well, Your Honor, the statement that they didn't involve the same claims is exactly why the motion court was wrong. The test is not, do they involve the same claims? The test, and this is in Chavez and American Pipe and numerous other decisions, is whether the same facts are alleged so that the defendant...
No. It's not the same facts. It's whether the same causes of action have been claimed.
Your Honor, I would say we cite a whole bunch of cases that say different. Indeed, I don't even think HSBC would say that the test is the same cause of action violated. That's just, I'm not going to repeat. You all have access to my briefs. The law is clear that the question is, was the defendant in the class action giving notice?
Well, so wait, if the claims expired before the BlackRock action, then tolling doesn't matter, right?
I'm sorry, Your Honor, if the
claims expired before the BlackRock action was commenced, then tolling doesn't matter, right?
If that were true, yes, sure.
Well, that's what the trial court basically found, that they were all expired, right?
Tell us why they're not.
No, Your Honor, I don't believe so. What the motion court said was they weren't. It said several things. Let's start with the word in the BlackRock class action. In the BlackRock class action, they allege all.
I would really suggest you focus on my colleague's question, because the questions we ask are the issues we're focused on. So tell me why these actions are not time barred.
Because they're told by the BlackRock.
Okay, but let's start with when the actions accrue, okay?
Yes, sure.
So we're talking about breach of contract, right? And the contract is breached for some of them in like 2006 and 2007, right?
Oh, no, Your Honor. And that argument, which was made by HSBC, indeed, the motion court recognized that that was not the law. This court in IKB made clear that the test is completely different. The test is, when does the claim against the obligor accrue? And we argue, and the motion court, I think, accepted with respect to two trusts, that the earliest that could have occurred would have been almost a year after the trust closed. Then,
Okay, so let's
that's
say.
the claim against the
So,
obligor,
right,
Your Honor.
okay.
And then, as this court held in HSBC and last summer in MLRN, then the trustee had a reasonable time, which in MLRN this court held was a question of fact for trial, but at least 6 years to do something.
Right, so it's like 2012 is the max. So if 6 years is the max, you don't get 30 years. You never get 30 years, right?
No, Your Honor.
Right. So the max would have been like 2012.
Well, no, Your Honor, because that ignores when the claims accrued. The claims against the obligor don't. This is not a rep and warranty case.
Wait a second. When are the documents received? Right? When is the obligation to look at the documents and decide whether or not they're sufficient?
Well, Your Honor raises an excellent point. The documents are received over time through
during the time of the closing. You don't get documents 6 years after the closing, right?
No, but Your Honor, you could get documents much later after closing. The PSA specifically provide for that. Indeed, the custodial agreement for the default 2006 AR6 trust notes the custodian's obligation at any time during the life of the trust to identify missing documents, and the PSAs all set forth a process on closing.
On all of these PSAs, none of them have a date past April 2008. So if we were to add 12 years to that 2008, that takes us to 2020, and these cases were commenced in 2021.
That's because plaintiffs are entitled to class action tolling, Your Honor, which is another, I believe, 1,600 days, and there's pandemic tolling for another 229 days. So there are all sorts of different tolling, but the class action tolling is the big one.
No. The obligation is to repurchase, right? That obligation can only last 6 years after the closing.
Oh, Your Honor, respectfully, I disagree.
Okay. Well, let's assume that that's what I think it is.
Well,
If it's
but
6 years,
can I explain why, Your Honor?
sure.
Please. What Your Honor said is the rule in a breach and rep and warranty case. For example, the Court of Appeals ACE decision. Because as a matter of long-standing New York laws, Court of Appeals recognized a breach of a rep and warranty accrues, if at all, on the day of closing, because it's a promise on the day of closing.
You're alleging that they breached the obligation to repurchase. That's your allege, that they have an obligation to repurchase, right? And that breach of contract claim can only be 6 years after the closing. You can't have the obligation to repurchase 30 years later.
Well, no, Your Honor, because this isn't a rep and warranty claim. There is a contract. And
All right, I'm going to allow you, because you have repeated that same argument 3 times now, so I will allow you to do it again on your rebuttal time.
Thank you, Your Honor.
Thank you. You may proceed.
Good afternoon, Lauren Ulig on behalf of HSBC. The parties.
Could you bring the mic closer to you so we can hear you? Go ahead.
Is that better?
Better, thanks.
The parties have raised a number of issues on appeal here. In order for Mr. Zitman to reverse his case's dismissal, he would need to be correct on each and every issue, and he's simply not. The panel need not
They had
engage.
to run the table, but in fact, they come up snake eyes. That was from your page 2 of your brief.
You're correct, Your Honor, yes. The panel need not grapple with every single issue because any issue on its own would be sufficient to affirm the trial court's decision. I'd like to address 2 specific points in the very short, limited time that I have. First, on page 25 of his reply here, Mr. Zitman concedes that his claims on 3 of the 7 trusts are time-barred even if he wins all the issues on appeal. So those are out of the case. He raises on his reply for the very first time another argument to try to salvage those claims. That, of course, under precedent is waived. He forfeited by not preserving it in his opening brief. The second point I wanted to raise was that Mr. Zitman's claims on all of the trusts can be resolved very simply because, as the trial court found, class action tolling simply doesn't apply.
I'm sorry, I didn't hear the last thing you said.
Class action tolling simply doesn't apply.
Why?
The trial court found 2 independent reasons, and both of them are right. But I'd like to focus on the point that Mr. Zitman is and never was a member of the BlackRock putative class. He doesn't dispute he didn't acquire the certificates until 2021. If the court looks in the record at 3844, you'll see that he acquired most of the certificates the day before he brought suit. So there's no way that he meets the class cert definition, which is current.
He argues that those certificates would have come from a class member in the BlackRock case. Is that not true?
That's not true, Your Honor. So he comes up with this argument. Clearly, he's not a member of the class. So he would like the court to make new law and say that 13-107, General Obligations Law, conveys American pipe tolling. There is no precedent to support that argument, and he musters no case law in support of it. I think in his reply, he cites a couple of trial court opinions on 13 and 14 of his reply. Neither of them even mention 13-107. And the reason why there's no case law is because doing so would contravene the Court of Appeals decision in Chavez, which adopted American pipe tolling for the very narrow rationale that American pipe tolling is really made to protect unnamed putative class members so that they can rely on class representatives to represent them.
Let me just go back. So the obligation that plaintiff is alleging that you know, you should have seen that I didn't have the allonge, there were the defective documents. That lasted for 1 year, right?
Correct, Your Honor.
So after 1 year, so assume that during that 1 year from 2006, you had the obligation to look and see. And then at the end of that year, the obligation went away. So that obligation, a breach of that obligation had to have accrued sometime between 2006 and 2007, correct?
Yes, all the trusted issue closed
So
in 06 or 07.
6 years for a breach of contract claim, right, is, except for I think 3 of them may not have had, there may have been a couple that we could argue about, but let's say for most of them. It ended 2013. The class action lawsuit didn't even start until 2014. For them, it's done, it's over, right?
That's correct.
Now, there are some that you could argue it wasn't clear when they had to do it, right? But it, at maximum, had to be 6 years and then 6 years, so 12 years, right?
Well, so Your Honor, the specific allegations in this case, Mr. Zitman actually alleged that HSBC received notice of doc defects and it conveyed that notice to the obligating parties at and around trust closing. So his allegations mean that accrual happened within the first year after trust closing here. You look at those in conjunction with the PSAs, of course, that means that we're talking about 6 years at a max from trust closing.
6 years, and then say 6 years for the CPLR 33122 statute of limitations, max, right?
Are you saying 6 years after?
6 plus 6.
So, Your Honor, I would respectfully disagree with that. I do think it is under.
But even then, it would be 2018.
Under the 6 plus 6, at a maximum. You are correct.
Right?
Yeah, it would be 2018.
Okay. All right.
Thank you, Your Honor. We ask that the court affirm the decision below. Thanks.
Thank you.
Your Honor, if I may, I want to start out by answering what I understood Justice Scarpula's question to be, because there was some discussion of it here. I think, and this is, I think, contravening the very explicit holdings of IKB and MLRN, the suggestion that the claim against HSBC accrued a year after the trust is completely opposite to this court's prior holdings. Rather, there's a year.
I mean, I sat on the companion case to that. I think that's exactly right. I think that you can't have a statute of limitations on one of these. You can't come in and buy it in 2021 and then allege a breach that goes back to 2012, right? And rely on class action tolling that you weren't a member of that class.
Well, Your Honor, first, the claim that accrues in around 2012, and we would argue later, but let's say around 2012, is not the claim against, is when the claim against HSBC accrues, not when it runs out. And so then there's 6 years in which whoever owns the certificate at that time could have brought a claim against HSBC. So 12, 13, 14 goes on.
So you're talking about till 2018. You bring your lawsuit in 2021.
But Your Honor, the claim against HSBC, we're told.
Okay, so I guess if we don't agree with you, you weren't a member of that class, the claims aren't the same. If we don't agree with the tolling, then you're out, correct?
Yes, Your Honor, I believe that's so.
Okay, then fair enough.
Now, the Blacklock class action complaint is explicit. It refers to the duty to cure document defects. It refers in the cause of action for breach of fiduciary duty to HSBC's failure promptly to enforce the trust rights, to have that cure. All of the facts necessary to prove those allegations in that class action, that's all that's at issue here. It is exactly the same facts. Now, it is true that a claim for breach of fiduciary duty.
I'm going to give you, see your red light is on. I'm going to give you another 30 seconds to wrap it up.
Thank you, Your Honor. It is true that a claim for breach of fiduciary duty may require more proof and different facts, and it's true that a claim based on event of default may entitle the plaintiff to more damages than we seek here. But the fact is exactly the same facts at issue in that class action were told here. And I would note that HSBC says, without any support in the law, that the statute of limitations that comes from that tolling does not go to the subsequent purchasers under general obligation law.
Thank you. Thank you. We're out of time.
Yes, sir.
Have your papers. Thank you so much. Ortiz versus City of New York.
Good afternoon. My name is Lauren Donnelly, and I represent the defendant respondents in this matter. The lower court properly determined that questions of fact exist as to whether Labor Law 240 was violated, and also properly dismissed the Labor Law 200 claims.
If there was no ladder available for this worker to perform the function he was assigned, which was to work at that mid-level platform, and there was no ladder attached to get him to that mid-level platform, how can there be any finding that he was the sole proximate cause under our case law?
Okay. We're not contesting that the court erred in failing to decide that there was plaintiff was the sole proximate cause. We are agreeing.
No, I'm saying there's no evidence of sole proximate cause.
Okay.
So how is it that 240 sub 1 should not have been granted in this case?
Case law says that the ladder does not have to be in the immediate area. There was one readily available.
The one that your witness, Mr. Drezick, referred to was a very tall ladder that was affixed to transport workers from the 3rd floor to the 4th floor. This was a midway point, which would have been half the distance. And Mr. Dresick, in his affidavit, which I reviewed several times, nowhere does he say that the workers were instructed to move ladders.
The law does not require that there be a specific.
Oh, yeah, no, in order for us to find that a worker was the sole proximate cause, the defendant, has to establish that the worker knew that there were available ladders, that he failed to use it for no good reason, had been instructed to use it and failed to do so. And Dresick's affidavit does not give me any of those things.
But in this particular case, plaintiff did not establish a prima facie case. So no matter what the defendant, the plaintiff said his whole argument was based upon.
You guys also moved for dismissal, right? So you had to make your own prima facie case, right?
Right. But in their prima facie case, the light is in our favor, and they look at our evidence in the most favorable to the respondents. Plaintiff, the whole argument was there's no ladders available. But meanwhile, he testified that.
That is not what he said. We looked at the EBT. That's not what he said.
He said that he had used the blue pipe ladders prior to get to the level of the planks. There's no evidence that or it's pure speculation that the ladder was too tall to get to those planks. And there's questions of fact based upon the competing affidavits of plaintiff, which was submitted on reply, which was improper, and also, and the Dresick affidavit. We're saying this should go to a jury. Let the jury decide. It's credibility determination. Who's more credible, plaintiff or Mr. Dresick? And let the jury
decide. On a 240 sub 1, it's not a credibility issue. This is a strict liability statute. And the issue is whether you have established your lack of liability under the strict liability statute.
We established that there are questions of fact as to whether plaintiff was the sole proximate cause.
No, wait, but did anyone ever say that they told the plaintiff to use this ladder?
He said, the Dresick affidavit said that he knew.
No, he
in
knew.
this particular instance, there's no evidence in the record. I agree
Let me interrupt you for just 1 second and say he couldn't possibly know what somebody else knows. I don't know what's in your head right now. You don't know what's in mine. My question to you is there any evidence in the record that anyone told this plaintiff, use that ladder? That's it.
There's
And
no
if there's not, then there's no sole proximate cause. You have to show that somebody was told and refused to do it.
And there is evidence in the Dresick affidavit that he knew of it. Whether he specifically told, I don't see
okay,
that.
so let me ask you. I'm sorry.
Go ahead.
I have to ask you, how could Dresick know that plaintiff was told that?
He doesn't, and he does not say how. I agree with you.
Know what's in somebody else's head.
Yes.
It would only be he could say, I told him.
Right.
He doesn't say that.
No.
But we just feel that especially obviously with the labor law 200 dismissal, that was correct. And with the labor law, we think it should go to a jury and let the jury decide whether it's 240.
Thank you.
Thank you.
All right. Floral Park versus Nationwide. General.
Put this up a little bit.
You may proceed.
Thank you, Your Honors. Good afternoon. I'm Stephan Belinfanti on behalf of the appellant from Law Office of Gary Serlman, PC. In this case, there are several reasons why the arbitrator's decision was irrational. But I'm going to give a conclusion.
And I want you to, because the difficulty on these cases is you understand the confines under which this court can review.
Yes.
Okay?
Yes.
So it is a very tall mountain to climb
Yes,
on
it
these
is.
cases.
Yes, it
So
is.
keep that in mind as you move forward.
Yes, absolutely. And each one of these reasons is enough to meet that burden, but certainly collectively it is. The first thing is that the basis of the denial is not a defense in the regulations. It's just not a defense. And there are no-fault regulations are to be strictly construed. The legislature, when the regulations were promulgated, they put in all the conditions, the exclusions, and the defenses that could be asserted against the claim. You cannot go outside those defenses.
Except
So I
that's,
could write
go
a
ahead.
prescription like on some birch bark and give it to a pharmacy, and that wouldn't be a reason for denial?
I'm sorry, can you repeat that, Your Honor?
In other words, I'm making up a hypothetical.
Okay.
So, say I pretend I'm a doctor, and I write out a prescription on birch bark, the white bark of a tree used to be used by people back in the day. And I submit that to a pharmacy.
Right.
And the pharmacy says, what is this? Get out of here. And then I say, you've got to honor that. Do they have to honor that? I mean, because it's not part of this, the regulation that you're invoking?
Well, that's controlled by a different law. That's the public health law that you're talking about. But the public health law specifically states that, because that's the basis of the arbitrator's decision.
Yes, but we can't look at, in the law, we are often called upon to combine a number of statutes together.
Right.
And see how they apply and interplay with one another, and that's what we have here.
Right.
So why, in the interplay of the two statutes that the arbitrator considered, why is it arbitrary and capricious when there is a law that says you must have an electronic filing?
Because that's not what the law says. The law says that public health law is the enabling statute, and it says regulations will be promulgated that determine when you use an electronic prescription. If you look at the regulations, and what's interesting is the link that the arbitrator puts in his decision specifically states the pharmacist, this is in the regulations, the pharmacist is not required to verify the reason for a written or oral prescription. And on top of that, the education law and the public health law allow the pharmacist to accept non-electronic prescriptions. It's right there in bold at the very link that the arbitrator cites to. So not only does he go outside the no-fault regulations, he cites to a law which on its face is the exact opposite conclusion, the exact opposite of the conclusion reached by the arbitrator. It says on here, the practitioner, this is the regulation, the practitioner is not required to indicate the circumstance of the written or oral prescription. And that's because there are many—
But that's not an issue we have in this case, right?
No, but it is, because the basis of the arbitrator's award is that public health law 283 was not followed, but public health law 283—
I thought the basis for his decision was that the prescription, since it wasn't electronically filed and was done orally, was not in compliance with the legislation requiring an electronic prescription being sent to the pharmacy.
But that is public health law. He cites to it. That's the legislation.
Okay.
That is that's what he says. He says the public health law. He says pursuant to public health law, you have clause. You have to use a electronic prescription.
Right.
That's what he says. But if you look at public health law and you look at the regulations that were promulgated pursuant to public health law, which is only a one-sentence thing, and it says, look at these regulations. The regulations on their face say that that a pharmacist can accept a non-electronic prescription and is not required to verify the reason why he got an oral or a written prescription. So how can it be rational? How can an arbitrator— this is at the link that the arbitrator himself puts in his in the decision. How can it be rational for an arbitrator to say that according to public health law, you got to use an electronic prescription? Here's the link, and when you click on the link, it says the exact opposite of that.
But
that is irrational.
Doesn't that regulation arise from the education law provision that you're relying on? It does, right?
So basically, public.
So if you see, the problem we have is like, if an arbitrator's got any anchor to the law, we allow that, and there might be conflicting laws, and I agree with you. There's some contradiction between these two statutes, but there's, the public health law right there saying it has to be an electronic prescription. And
but it does, Your Honor, I got it. But it doesn't say that.
All right.
It says—
Counsel, stop.
Yes.
You're out of time.
Okay.
Have a seat. You'll have time on rebuttal.
Good afternoon, Your Honors. May it please the Court. Brian Kaufman for Respondent Nationwide. The Supreme Court properly denied the petition to vacate the arbitration award as it was neither irrational, a violation of public policy, or in excess of the arbitrator's authority. When Nationwide denied the claim, they denied the claim based upon the plain language of the no-fault regulation and the insurance law, which implements that regulation. And under that, it says that as far as medications are concerned, reimbursements are only available for a prescription drug. Now, what is a prescription drug? Well, the arbitrator looked to the language of the public health law and the education law to determine what is a prescription drug. And that is not arbitrary or capricious, neither is it irrational.
Think that the public health law says it requires an electronic prescription, and it says that it applies notwithstanding any other law to the contrary, right? I mean, I'm looking at it right now. It says this applies notwithstanding any other law to the contrary. So it would seem to me that if there was another law that said that you could get reimbursed for an oral prescription, this requirement of an electronic prescription trumps it because it says notwithstanding anything to the contrary.
So, I mean, that was a factual finding of the lower arbitrator, which I don't even think would be available
Right,
for
it's
review.
okay, but let's just even, right, but you're saying it was at least rational for him to look at that and say, since it wasn't here, then we don't have an electronic one.
Right, that's correct.
It's not like he made up this public health law.
That's correct, Your Honor. And the issue is that it was initially alleged that it was an electronic prescription. It was only at the hearing that counsel conceded and the arbitrator, the lower arbitrator, not the master, noted in her decision that applicant made the contention at the lower hearing that it was an oral prescription, but there was no record of that. And just so there's a little bit more context to this, the EIP in this instance happens to be the owner of the pharmacy. And there was a transcript from another doctor who was presented at an EUO with similar scripts, and she indicated that she had never seen those scripts before, and they were not hers. And the lower arbitrator in this instance noted in her decision that the report that was presented along with the prescription was not signed by the doctor whose name was allegedly on the prescription, which again was not signed. It was not a written prescription. You know, in those limited circumstances.
But I mean, wasn't it conceded that Dr. Lee called the pharmacy and put in this prescription?
No, this was not, in this instance, it wasn't Dr. Lee. There was no, it was counsel's argument at the hearing that it was an oral prescription.
I thought that everyone agreed that Dr. Lee had made the oral prescription.
No. No.
Oh, okay.
In the witness had appeared for an EUO as the owner of the pharmacy, and he testified.
He's the one who said, "Oh yeah, Dr. Lee called me."
Well, he said, I mean,
Dr. Lee never put in an affidavit.
well, in this instance, it wasn't Dr. Lee who was the prescribing doctor.
Who was that? Who was the doctor? Dr. Rahman Quasi?
Dr. Rahman, if I'm
Rahman Quasi.
Quasi.
Yes.
Quasi Raman.
And did did he put in an affidavit saying I called it in? And
There's no indication of that.
it was only the pharmacist who was saying that someone who identified themselves as this doctor called in this prescription.
I don't even think the pharmacist said it as it relates to this specific claim of him. He was saying that all the prescriptions come in electronically. The transcript of Dr. Lee was offered to the lower arbitrator to show that that's not correct.
Oh, I see what you're saying.
Yes.
That it's just as a general matter, some of them, but there's nothing about this specific prescription being orally called in.
That's correct. There's no evidence. It was at the hearing, applicant's counsel said, well, I acknowledge it wasn't an electronic prescription, it was called in orally. And the lower arbitrator noted that while he's an officer of the court, there's no affidavit from anybody saying it was an oral prescription.
So I appreciate how that would cure the issue that you're talking about. Having it all be electronic would cure the issue of whether or not, in fact, it was called in or not called in. But aren't there circumstances where a doctor may have to call in a prescription like on a weekend when they're not in their office and they have to attend to their patient and they call it in? Shouldn't they be able to, the pharmacy, get reimbursed under those circumstances?
Potentially, but that's not the facts that we're presented with in this instance. Again, there's no indication that this was an oral prescription. And I believe the public health law indicates that oral prescriptions can only be called in under certain circumstances. So, I mean, and there's no indication that it was an oral prescription. Again, and I see I'm out of time, but the EIP, who is the owner of the pharmacy in this instance, testified that the prescriptions come in electronically. And that was his testimony. And then, so it was Nationwide's position that this is not an actual electronic prescription. There were none of the hallmarks or features that you would see on an electronic prescription in this prescription at issue. It wasn't signed digitally. It indicated on the side pharmacy that it was created by the actual
I have a question, if I may.
Yes, Your Honor.
Regardless, were these medications that were dispensed to this person, did they require a prescription, or were they over-the-counter medications?
It's a good question, Your Honor. These medications, well, so if it was an over-the-counter medication, then it wouldn't be eligible to receive no-fault benefits. The pharmacy wouldn't be able to receive.
These medications are not over-the-counter medications.
I believe that is correct, Your Honor. There are some medications that can be over-the-counter and that can also be available as a prescription. I don't believe that was the case in this instance. However, an over-the-counter medication is not reimbursable. That's why it's the term in the regulation that Nationwide relies upon is prescription drug. So what is that? The arbitrators look to the education law and the public health law. It's Nationwide's position that that was not irrational for them to do so.
Thank you.
There's nothing further. Thank you, Your Honor.
Yes, understood.
Counsel, you have 1 minute.
Yes, Your Honor. Public health law says that regulations will be promulgated to determine when an electronic prescription shall be written. Those regulations give 10 exceptions to the electronic rule. And the regulations say that the doctor, prescribing doctor, does not have to specify why it's an exception.
So that, I guess I have to ask you, is
Yep.
there any direct testimony that this was an oral prescription other than the pharmacist who received it? Is there anyone saying, yes, I sent in an oral prescription?
Is there any testimony? No,
Is there any affidavit?
there isn't, but that
Is
was
it, all
the
there
basis.
is the pharmacist who said, oh yeah, this must have been oral?
Well, the basis of the, just to be clear, the basis of the denial is that it's not an electronic format.
Right, and right, so
Which is not required by the regulations for a pharmacist. He can accept on their face, the regulations that is relied upon by the arbitrator says he can take non-electronic prescriptions and does not even have to verify why it's non-electronic. This is not, it's in the public health law that counsel is citing simply says that we will promulgate regulations that determine this. And the regulations on their face say that. And so to petitioners or to appellant, it is irrational for an arbitrator to rely on a law saying it says that you have to accept only electronic prescriptions, but when you look at the law, it says the exact opposite thing. And it says, the arbitrator actually says, the pharmacist didn't verify why one of the exceptions to the electronic rule.
Thank you.
But the public health law says we don't
Counsel?
have to. So
Thank you.
thank you.
Seibel versus Ramsey. You have 6 minutes. You may proceed.
Thank you, Your Honor. Good afternoon. May it please the court, this is Paul Sweeney on behalf of the plaintiff appellant. This is an appeal after a bench trial. Plaintiff's claim for breach of contract, which was based on the defendant Ramsey's closure of the restaurant despite there being a unanimous consent provision, and my client clearly did not consent to it. The court below permitted that clear breach based primarily on the doctrine of in pari delicto. That is a clear error for a number of reasons. First of all, it was not pled. It was not pled as a defense in this case. Second of all, the court applied New York law. Delaware law or California law are the laws of the agreements that apply to this case. Under those laws, the facts of this case clearly do not support.
Even if we agree with you that the trial court erred in raising pari delicto sua sponte, didn't they, your opponents also talk about frustration of purpose and impossibility? So don't those fit the facts as well?
They do not, Your Honor, respectfully. The court below based its, and it didn't specifically address frustration of purpose or impossibility, but it appears that was the defendant's argument and that's what it was talking about. It based it entirely on facts that arose after Mr. Ramsey decided to close the restaurant. He admitted he made that decision to close the restaurant in June of 2013, about 8 months after the restaurant had opened. All of the facts cited by the court and all the arguments they made were based on facts that arose subsequent to that. Just as a matter of chronology and sequencing, those facts that arose later on cannot form the basis for impossibility or frustration of purpose. And I'll give you an example.
I thought the taking of $80,000 from the restaurant happened beforehand.
It did not. The first time that happened, there was $70,000 that happened in September of 2013, a number of months after they admitted they had made the decision to close the restaurant.
But before it actually closed.
But before it actually closed, but they had already made the decision. You can't claim my decision was valid because of something that happened 3 months later. And that decision, which was also based on, obviously my client contests that was
but a decision that hasn't been acted on is just a thought, right? It's just an idea.
Well,
It's not an actual fact until you do it.
But what they did.
Am I right? I mean, they're saying they're going to close it in a few months or whatever. Well, that hasn't happened yet. And in the interim, $70,000, $80,000 gets siphoned out of the restaurant. It seems to me that then 3 months later, even more reason that we've got to close.
Well, first of all, Your Honor, so the reasons didn't exist when they made the decision. You can't say frustration of purpose based on something I don't know that's going to happen.
And what? Tell me what in the record supports your statement that the decision had already been made.
Mr. Ramsey's testimony. Okay. It's cited in my brief.
All right.
He admitted that the decision, as did his primary business counsel, admitted the same thing, June of 2013. And Mr. Siebel did not siphon money out. Part of that decision by the court disregarded all of Mr. Siebel's testimony. But there was an agreement between the parties that a certain employee would be paid for solely by Mr. Ramsey personally because she was also doing work for his other restaurants, and Mr. Siebel did not think she was particularly good at her job. So when Mr. Ramsey took money out of the entities to pay that employee, Mr. Siebel took the exact same amount out because he believed Mr. Ramsey had breached that agreement, and Mr. Ramsey at trial admitted he couldn't remember whether there was an agreement or not. So all the evidence at trial showed that, in fact, Mr. Siebel's recollection was correct. So frustration.
But that's your view of, you can't, and we're not going to change the trial court's credibility determinations, right? Well, let me ask you this, and plus there's no, what did your client say was the damage? I thought your client said, yeah, it had to be dissolved. We were never going to do it. We were never going to be able to go forward. So what's the damage? If both parties think it's supposed to be dissolved, what's the damages?
No, Mr. Siebel, the restaurant closed in 2014. During the trial of a year ago, there was a dissolution claim, and at the end of the trial, he was no longer going to contest the dissolution in 2023.
Right, okay, fair enough.
He absolutely disagreed with dissolving it back then at the time. He didn't agree to close the restaurant.
So even if Mr. Ramsey said it wasn't making money, right, he didn't close it until after it didn't dissolve until after the conduct, right?
The restaurant was closed in March of 2014.
Right. When did the $80,000 get siphoned off?
September 2013.
So that's before the restaurant was closed.
Right.
All the bad behavior was before the restaurant was closed. Ramsey might have thought to himself, this is not going to work out, but he didn't do anything to close the restaurant until after the behavior, correct?
Absolutely did. He made the decision, and what he started to do was to secretly set up the restaurant that was going to
take the trial court didn't accept that. So we're on appeal. right? The trial court didn't accept that.
Except which part of that?
The secret and all this.
Well, no,
The trial court said, what the trial court found was that he was breaching the contract, and yes, we all agree, impera delicto, but two, that he hadn't proved any damages, right?
Well, yes. So
okay.
First, she found that he didn't. Mr. Ramsey didn't breach the contract, and she missed the chronology because the decision was made beforehand, as we discussed. She also found that damages were not proved. She did not believe their plaintiff, who's the only restaurant expert that testified in the case, only one with expertise in that particular restaurant market. The judge didn't believe her, but even
yeah, but her opinion was based on speculations about how the business could improve, based on the back of Ramsey's reputation, which was a ridiculous suggestion since Ramsey didn't want anything to do with this venture anymore. So her entire speculation about how this restaurant could take off and actually make money was on a flawed premise.
Well, it was based on events that were supposed to happen subsequently, like the changing of the name of the restaurant and the exposure they would get from a TV show. But Your Honor,
again, all of it relying on the name of Gordon Ramsay. So the plaintiff's expert's opinion about the viability of a successful restaurant rested entirely on the back of Gordon Ramsay's name and reputation.
In part, it did. In part, it did, Your Honor.
Almost completely.
But even if the court was correct in saying it was too speculative, their own expert admitted that an alternative method of determining the damages is if you have any offers to purchase. That's how you determine value. They had made an offer to purchase, to buy Siebel out. That is a basis for damages. Their own expert said that is how you determine the value of the enterprise, what a willing purchaser was willing to pay at the time. There was testimony in the record that that is exactly what happened. And so $800,000 approximately is what was being offered. Let me address one last point.
You'll do that on rebuttal. We're over time.
Good afternoon. May it please the court. Kevin Gott on behalf of respondents. I'd like to first address Mr. Sweeney's arguments about in peri delicto. I think it's important to first recall that that was not the only basis for the judge's decisions, and there were several reasons why this was not.
Right. So let's just assume. Let's leave in peri delicto. Right. It wasn't raised. Let's say. Let me ask you this: do you agree with counsel that all the breaches happened after the Ramsey decided to close the restaurant, and therefore breach of the agreement could not be a basis for?
No, I disagree with that for two reasons, Your Honor. First of all, you have to put this in context. What they're talking about in June of 2013 was there was a discussion between Mr. Ramsey and Mr. Siebel that Mr. Ramsey was going to buy him out. And it's true, at the time, it was already a disastrous enterprise.
Right, okay.
And it's true at the time that what Mr. Siebel and Mr. Ramsey were discussing was, Mr. Ramsey, once you take over this restaurant, you're going to have to change it. And it's a little ironic that they keep saying that Mr. Siebel never knew about this decision, because that was the very thing they were discussing in June of 2013. Now, what happened afterwards is that was a decision that was going to be made when voluntarily there was a buyout agreement. What happened afterwards, of course, is they weren't able to reach that agreement.
And then he finds out about all this other
Right.
stuff, and he says, okay,
Right.
it's done. Let me ask you the second question about the breach of contract claim, which is, do you agree that your experts said that there could be damages based on the fact that you made an offer to buy out his
No,
house?
Your Honor, and I hope the court will look carefully at the references to that, because what is cited is actually their expert, who says he would not give credence to an offer that's not made. So they cite to our expert who says, geez, I wouldn't credit the growth rate that is speculated by plaintiff's counsel. So there's no evidence of that.
And so it's just basically the trial court saying, I don't find this expert credible. I find your expert credible on that issue, right?
Right. And I would continue on that alternative damage point that there was no agreement on a dollar price. The big issue was indemnity. In fact, his lawyer says indemnity.
Okay, well, that's where I want to go next. So the indemnities, the indemnity is to Ramsey himself, right? The court issues a damages award for money that's paid by his corporation.
Yes. You mean for Mr. Ramsey?
That's a problem.
Well, I don't think so, Your Honor, for
Did
really.
you plead alter ego?
No, but
Did
remember.
you plead pass through?
No.
Did you make any showing at trial about that issue?
Yes. The showing that we made, Your Honor,
Did you
was.
ask to amend the pleadings to conform to the proof?
I don't think we need to do that, Your Honor.
You agree that the indemnification is only to Ramsey?
No, I don't, Your Honor.
What is
Because
the indemnification agreement?
the indemnification agreement, first of all, says that it can be monies incurred by Mr. Ramsey. It doesn't say it has to be paid by Mr. Ramsey. It has to be incurred.
Who incurred the liability when they paid the rent?
Mr. Ramsey individually.
He paid the rent.
He incurred the liability.
No. You can't, that's silly. Who paid the rent?
It was paid by one of his entities.
So he did not. And when that entity pays the money, right?
Right.
Does he pay, does that entity and him are the same person?
They're not the same person.
Does that entity file its own taxes?
I'm assuming it does.
Of course, right?
Yes.
That's the whole purpose of having that corporation, so that its liabilities don't come back to him, right?
Yes, but he couldn't avoid the.
You're smiling at me because you know that this company paid this liability, not him individually. No. And the indemnification went to him individually, correct?
The indemnity went to him individually.
And the corporation incurred debt by paying the rent.
I would not agree with that, Your Honor, because he signed the lease individually. He had the liability. If it wasn't paid, it was his individual liability.
Did he pay the company back for the money it paid?
I don't know. That's
yeah,
not
of course. Did you put in any information
did
about
not.
that?
We don't
know. So the only person who incurred a liability who's going to show it on their books is the company, right?
Yes, but it also says, Your Honor, that the indemnity can extend to his representatives, and this was his representative. And I don't think it makes a lot of sense.
No, it says his assigns.
No, it also says representatives.
That's right, representatives, right.
And there was evidence in the record, and we cited it, that these were his entities. They were owned by him. They were paying the amounts in order to satisfy an obligation that he ultimately owed. If they didn't pay it, he was individually on the hook.
If they didn't pay that, right?
Right.
And if the corporation gets profits, does he pay personal income tax on the profits that the corporation gets?
I assume not, but
assume not, right? So you can't have it halfway. You can't take the benefits of having the corporate form and not accept the corporate form as it is.
Your Honor, I think we're looking at the wrong side of this, because the idea is that the other side is supposed to take care of an obligation that belongs to Mr. Ramsey or his representatives. And that's what happened here. That's what we got. It doesn't really make sense to say that just because he chose to have it done through his entities, that changes.
Why didn't he pay the rent himself if he was the lessee?
I think he just chose to have his entities pay it. I mean, I don't know that he couldn't have done that, but he chose to have it done that way.
Thank you.
Thank you.
You have 2 minutes.
Thank you, Your Honor. On the indemnity point, there's no evidence in the record as to Mr. Ramsey's ownership in the entities that paid it. And in fact, they objected to producing evidence during discovery as to one of the entities, Appellate, and the witnesses who testified at trial could not state Mr. Ramsey's ownership interest in those entities.
Is there anything in the record that would say that that company is, for example, solely owned?
No.
Is there
Nothing.
anything in the record that would say that they share offices? That anything
Nothing.
that would
Nothing.
say it was a pass-through?
Nothing.
Is there any representative agreement
No.
between Ramsey and the company?
No, Your Honor.
Okay.
To move on, Mr. Gaw was explaining, there was a buyout, and they were just moving on from that as time went on, and eventually they closed in March of 2014. You have to ask yourself the question, why then did Mr. Ramsey repeatedly lie? Why did he repeatedly lie about his reasons for closing the restaurant? It is proven in the record, is in the decision. He lied. He said he can't do business with Mr. Siebel. He opens up other restaurant with Mr. Siebel. He says Mr. Siebel was out there talking.
Well, that other restaurant, though, that was a favor for someone in Atlantic City, and he didn't actually have to work with him directly, right?
They didn't have to. Okay,
It's not like, all right, I'm gonna close this one, but come on, let's open up another one on Fifth Avenue. That's not what we have here.
Leaving that aside, there are other times Mr. Siebel was out there discussing other deals. Mr. Ramsey's team was fully aware of them. In fact, they started the discussions, handed them off to Mr. Siebel, and then they say the reason we have to be out of business with Mr. Siebel, he's out there doing stuff we don't know about, using those as examples, things that they started to negotiate and asked him to. So you have to ask yourself, if this was just all on the up and up, we were going to have a buyout, and then that fell apart, but we were just going to move on because financial things. Why did Mr. Ramsey keep lying? Why did he say it had to be closed because of the trademark when everyone knows that's a lie? He even admitted at trial that was not a reason. He lied
But again, you're
because he did it
asking
underhanded.
us to change a credibility determination. The court found certain testimony credible and certain testimony incredible.
Understood, Your Honor, but the one thing the court, that the error the court made is the falsus in uno, falso in omnibus, has legal standards for when that can be applied. She disregarded all of Mr. Siebel's testimony based on one incident that was not a material fact, nor was it demonstrably false.
We read that, if you read the PJI on that's exactly
That was one of my
what's
favorite
allowed.
charges at trial.
That's exactly what's
Okay.
allowed. If you lie about one thing, you can lie about everything. You can accept part of it, you can reject part of it. You can accept it all or reject it all.
Yes.
That's what the law is.
But the case law says it has to be material and demonstrably false. All the testimony at trial supported Mr. Siebel on that position. And so she's allowed to disbelieve him on something, but she can't use that fact to disregard the entirety of his testimony when that does not fall into the legal standards for applying falsus in uno, falso in omnibus. We also object to the attorney's fees finding of over $4 million. It was not based on any showing of reasonableness, and it was their burden. There are zero damages here. They got $4 million in attorney's fees, and they didn't carry their burden.
Thank you.
Thank you, Your Honors.